Afternoon, and welcome to the Student Safety and Wellbeing Advisory Committee meeting for June 2025. We are ready to call the meeting to order. We've determined that we have a quorum. We have those who are present, plus we have a couple of members online, and so they constitute a quorum. With that said, the agenda is before you, and I'll entertain a motion and a second on action for it.
So moved.
Is there a second?
I'd second.
Probably moved in second that the agenda be adopted. Any need for additions, changes, any comments? That being said, all those in favor, please signify by saying aye.
Aye.
All opposed? The ayes have it. The motion carries. The agenda is approved. We have a number of items under new business that we want to go over. The first is the preparation of a data assessment report. And I'm going to ask that Emily provide us with a little background on that.
Good afternoon, committee members. Emily Shrews, staff liaison to the Student Safety and Wellbeing Advisory Committee. In your packets and those joining online, if you have your packets up, you will see a data assessment report template. So we are asking, as we gear towards our final report preparation within the next few months, to have our subcommittees kind of work together to go over, what they've seen from presentations so far, from the data that they've researched within their own groups, to kind of make sense of, what they've seen and what challenges and gaps exist in what the committee has seen, and then starting to work towards recommendations and conclusions. So this is the chance for committee members to start to work towards making sense of the presentations and data that has come before the committee so far. In your data assessment report, you'll notice 3 different sections. You'll notice an introduction. The second section is just a report where you will give an overview of the data, the practices and procedures, etc., pertaining to your subcommittee. So, based on what you've seen relevant to your subcommittee, what are the significant findings? The third section is identification of challenges and areas of improvement. So based on the data, practices, and policies, and just the reports that the committee has gotten, what are some challenges and areas of improvement based on what we've seen? So the end goal for this is for subcommittees to have kind of a draft of these issues prepared for the next meeting in July. And one of our big items in July, in lieu of a presentation, will be kind of a work session, a roundtable work session with committee members to discuss, what was in their report, and maybe we can help each other as a group brainstorm and just make sense of, what the committee has seen. So I hope that makes sense to everybody. Does anyone, including my 2 members online, have any questions regarding this draft report? And if there's any questions regarding subcommittee membership and structure, please feel free to reach out after the meeting. But for now, any questions about the report itself?
Okay. Thank you. And again, if you need any assistance, please reach out to Emily, and we will follow up to make sure that all of our subcommittees are prepared to share their input at our work session in July. I would just like to add that I see us entering what could be very much the last quarter of our work, and so we really want to start pulling together the pieces. We have tried and been rather diligent about securing input from entities that you have indicated. When I say you, the subcommittees have indicated to our team that you'd like to hear presentations from, and today is a continuation of that. Item 2 of new business, we had agreed to do quarterly public input sessions, and our we have not had a robust attendance at the night meetings. And I would like to recommend that we move to a virtual public input session in the evenings, that we determine a date in July that we'd like to have that session, and that we move forward with having it sponsored and streamed on the county's through the using Microsoft Teams and through the county's communications network. Any need for discussion about that? Is there anybody opposed to such? Okay. When would you like to meet? Is there, would you prefer to stay with the Wednesday date?
When was it scheduled for the next quarterly?
We had not.
Was it 3 months from the last time?
Yeah.
So when was that?
Pull up that date, give me 1 moment.
Okay.
So our last public input session was in April. It was Monday, April 7th. So I would recommend for the committee to look at any date that is convenient for the majority that is not in that third week, to avoid 2 meetings in 1 week. So first week, second week, fourth week, I would recommend the committee to look at as a possible. And we have held 1 public input session at 6 o'clock and 1 at 6:30. So up to the committee to decide whether or not to keep that time.
Are we available on the 9th at 6:30? July 9th. It's the second Wednesday, 6:30.
I'm not, but I'm just wondering.
Okay. You good?
This is Leslie, I will be.
I have a meeting.
You have a meeting? Okay. What about the 8th? Same time.
Works for me.
Me too.
Works for you?
Yes.
Still good? Okay. On this end, we're good? Okay then. We will host that meeting on July 8th, 6:30 p.m. via Teams.
To confirm, was it July 8th or July 9th?
July 8th.
8th.
Tuesday, July 8th, 6:30 p.m.
Can we get a vote from the committee, please?
Would someone offer a motion?
I move that we have a virtual quarterly meeting on July 8th at 6:30 p.m.
Second?
And second.
Properly moved to second. Any need for further discussion? All those in favor, please signify by saying aye.
Aye.
All those opposed? The ayes have it. Motion carries. Okay. So, having that set, our next order of business is one that we have been waiting for and excited about, and I want to welcome Ms. Odoms from our local care team, Mr. Harvey and Ms. Brown from the State's Attorney's Office, and Mr. Is it Sasser? Sasser. You pronounce it Sasser. Okay, Sasser from the Magistrate's Office. Would you please come forward? I want to thank you for taking the time out of your busy schedule to be with us. We have been excited about the possibilities. Let me also say for the record that we, in our initial planning, had hoped that we would have a representative from Juvenile Services. However, given the recent administrative changes implemented by the governor, there has been a stay put on any public presentations from their members, and so we regret that they are not represented in this presentation, but we are thankful that you are here. And so we're going to start the process by passing the baton to Ms. Odomson.
I will take that.
All
Thank you
right.
very much. I am the local care team coordinator here in Calvert County. And for those who don't know, the local care team is in every county. And it was mandated to be in every county because of the effective cost savings to the state. Our first objective is to ensure that families have utilized all community resources before placing a child in an out-of-home setting, which the out-of-home settings, residential treatment centers, diagnostic centers are all very expensive and taxing on all of our agencies. So the partnership and the team of the local care team are representatives from all the child-serving agencies in our county, as well as nonprofits and other entities that have resources to share for our families to utilize in the community. And those resources encompass everything that you can think of. And we brainstorm with the families to come up with an action plan detailed based upon what they present to the team on what their needs are. Most important thing is that a family can self-refer. They don't have to have agency involvement already. They can self-refer and feel confident that the information shared is confidential and that our team is there literally to help them. All of the local care teams in the state are housed in the family networks, and in our situation it's a family network. Other counties call their local management boards other names, but under Jennifer Moreland here in our county. The eligibility to do that referral for a family or for an agency to refer them is very simple. They have to be a Calvert County resident struggling in multiple areas. If they're only looking for a resource in one area, I'm available by phone. They can call me, they can email me, and I can talk them through whatever resource it is that they're looking for. But when they're in need in multiple areas, the team approach, each person tells what the resources are that their agency or their company can offer them. And other than that, the family has to be willing to participate and follow through on the action plan that we give them. We also assign someone to them to follow through on that plan. Sometimes that plan can be a little overwhelming. You're getting resources from 14 people, and each person may have 2 or 3 thoughts. So we assign a case manager sometimes or a peer support person sometimes to help them work through that plan. In your packet, you'll see a flyer that we utilize to help promote it because many people don't know until they need something. Our schools are very helpful at helping us have community involvement to put this information out and this flyer in the hands of people. And after the flyer, you'll see the actual referral form, and you'll see the kind of information that's needed. It's pretty easy to complete, but I'm always available to help a family that may have some difficulty. And oftentimes, if they're being referred by the school system, then there's always a school staff that's always willing to help them as well. And the final page is the authorization and release of information. And we ask that that be signed for each child. Our approach really is a family approach. So there may be one child that was identified by a school employee, I'm going to use as an example. And then upon contacting the family, we find out that, you know, they have a child that's not in school yet and in need of services. And so we contact the appropriate people in the community that specialize in resources for that age group. Or we may find that there's an adult in the family that is disabled. Perhaps they're in need of other types of resources. So when I say resources, which I've said I know 100 times already, what do you think of? It's literally everything for our life. And if you're not the one going through a child with a special need, or if you're not the one going through a loss of a job or need of housing or how to pay their bills or any of the other aspects that go along with life, then you're like, okay, that really is a resource for everything. And I can't help but plug our Calvert.org. It is our electronic resource guide in the county, and the icons that we used on all of our promotion for that tie right into the local care team. It says resources for life, whether it be for transportation, whether it be for finances, whatever the need is, healthcare, mental health, there it is, everything. So if you are not already utilizing that website when you need a resource for something and you can't remember our Calvert.org, then try to remember my number, because you can call me at any time and I will do the website for you, or I will share the information that I already know for a resource that might be available for a family.
So it's just calvert.org?
Our Calvert, yes.
Our Calvert.
Mm-hmm.
Okay. Any questions?
I just wanted to make a comment about Arian because I wanted people to know how fortunate we are to have somebody with her experience working in this position. She has probably experience in every child-serving sector, and including adults and criminal justice as well. That's very important so that you can look at the full picture. We can get siloed in the human services world, and so I want families to know, and school personnel to know as well that she can be trusted as a very, very knowledgeable resource. Other counties are jealous that we have her. She helps other counties' local care teams with technical assistance and support. So thank you.
And part of that comes from my experience. I worked in Anne Arundel County. I was on the LCC, which was the local coordinating council. And Anne Arundel County's team became the example that the governor's office asked us to roll out to the state. So I've been doing this in Calvert for 5 years, and I brought the 10 years of experience from LCC. So that's part of it too.
Well, thank you.
You're welcome.
Mr. Chairman, may I ask a quick question? I know it's unusual, but so I just want to ask you this question for the understanding of the group and members of the public of how local care team intersects with other agencies. We know that the Department of Juvenile Services will sometimes refer individuals to the local care team. Can you speak to that, and maybe other agencies in the community that give referrals to the local care team?
Absolutely. So it's meant for us to all work together. So for example, Caitlin is a member of our team. Unfortunately, we weren't able to have our representative from DJS here. She is also a member of our team. And the members on the LCT are supposed to be the people who are most knowledgeable in their departments to share with other people the resources that they learn from being on the team, because they're listening to everyone's information. And DJS recommendations, sometimes their resources can only be tapped in from them, right? So they're looking for outside recommendations when they've exhausted theirs. And so that's a time when a recommendation or a referral will be done to us. And also it's that, what I mentioned in the beginning, that we're trying to avoid out-of-home placements. So when DJS is going to have to do an out-of-home placement, as well as DSS, as well as the school system, as well as our core service agency. They are all placing agencies that can have a child placed out of home. And the requirement is that the referral has to come through us first. We're the gatekeeper to show that all community resources have been exhausted before that placement can take place. So we work in harmony with each other, whether it's a referral or not. They can, you have a case manager that's working on something from one of the agencies and they can't quite figure out, well, what else can I do? Then I get that call.
Arian, can you expand a little bit on what a voluntary placement means for families?
So without there being a Department of Social Services representative in the office, I'm going to give a blanket statement, right? So the Department of Social Services oftentimes gets a bad rap when it comes to removing a child from their home and doing an out-of-home placement. They absolutely want to exhaust all resources, any family, anyone that is able to keep that child connected to what they're most familiar with. But when they get to that point, they don't feel that the child is safe in the community any longer, for example, due to perhaps their mental health needs. They do a referral to us to show, once again, all community resources have been exhausted. And then that child is voluntarily placed into one of those treatment facilities where they can get mental health and education at the same time. A family does not lose custody of their child, hence the voluntary part. Okay. And they are reviewed to see if in fact they can financially contribute to that very expensive placement. So they go through the actual child support system where that information is gathered and it's determined whether or not they can pay towards that. Their insurance is also reviewed to determine whether or not their insurance can pay it. So it's a very costly move, and it's not always the best for that child, but when that is the level of care that's needed, the Department of Social Services here in our county does more placing than any of the other entities and agencies that I mentioned. More children come through the Department of Social Services for an out-of-home placement than any other agency.
Is it fair to say that such actions by DSS are driven by social and familial circumstances versus educational?
It's a mixture, but quite honestly, most of the time, it's mental health needs that can no longer be handled in the community.
Okay.
They could already be receiving all of the resources that we mentioned and still are unsafe in the community.
Okay.
That's an example.
Okay. Thank you.
Mm-hmm.
Any other questions or comments? We may come back to you, but at this point, we'll go to our State's Attorney's Office.
Well, thank you. I want to echo what Jennifer said about the resource I have sitting next to me here. I've known her for many years, and she's doing a great job. I'm Bob Harvey. I'm the State's Attorney here in Calvert County, and I have with me Assistant State's Attorney April Brown, who handles the prosecution of juvenile cases in Calvert County. I want to begin by providing an overview of the State's Attorney's Office. You know, when I took over the office 5 years ago, somebody said to me, well, congratulations, you're the new State's Attorney, but nobody knows who the State's Attorney is, and nobody knows what the State's Attorney does. There was a little bit of an exaggeration in that statement, but some of it's true. If people don't have any reason to have contact with the State's Attorney's Office, they don't often know who we are or what we do. So I'd like to just give you a little bit of an overview of the State's Attorney's Office in general, and then we'll shift into the presentation about juveniles and prosecutions and so forth. There's 24 state's attorneys in the state of Maryland, one for each county and one for Baltimore City. The state's attorney is actually a constitutional elected office. It's in the Constitution of Maryland that each county in the city of Baltimore will have a state's attorney. And the statute says, rather vaguely, that the state's attorney is responsible for the prosecution of all cases in which the state may have an interest. Now, if you look at that, you would conclude that that doesn't have any meaning whatsoever. So what does that really mean? Well, it means essentially the state's attorney is responsible for the prosecution of adults and juveniles who have been charged with a commission of a crime. In Calvert County's case, it would be charged with a commission of a crime in Calvert County. Juveniles are not technically charged with commissions of crime. They're charged with the commission of an act which, if committed by an adult, would be a crime. But we're the ones who are responsible for the handling of those cases, whether it be adults or juveniles. And I have 16 lawyers in my office that assist in that prosecution. The county has been very generous to us in terms of staffing needs. 16 lawyers. The office has grown, I think, by 3 or 4 lawyers since I took office 4 years ago. And the total staff is about 40 people, including 3 criminal investigators who are actually sworn police officers and who have authority to arrest and investigate cases and so forth. So the state's attorney's office, we are in court every day. We were in court today. We'll be in court on Friday. We're off tomorrow. And we present cases, as we like to say, to judges and juries on behalf of the citizens of the state of Maryland and the people of Calvert County. We subpoena witnesses, we gather evidence, we do whatever is really necessary to ensure that the facts of a given case are presented to the court or to a jury fully and fairly. It's not about wins or losses. I know people think prosecutors carry a belt with notches in it. We do not. In fact, I frequently said when I was a younger prosecutor, anybody who claims they've won all their cases has never tried a tough case in their life, because it's not about winning or losing. It's about presenting the facts of a case to a judge or jury and then seeking justice and fairness. In fact, prosecutors throughout the state have an ethical obligation above and beyond what other attorneys might have to be fair and just and seek justice in every case. So I like to think that's what we do. We have very high ethical standards in my office. We've had numerous presentations on ethics. We just had something from Bar Council about what we need to do to make sure we stay out of trouble with the Attorney Grievance Commission and so forth. So we try and stay on top of things in that area. Adult cases and juvenile cases come to my office in sort of a different fashion. Adult cases, as you might be aware or guess, usually someone makes a complaint that a crime has occurred, or a police officer may see something that looks like a criminal behavior. Police investigate it, somebody gets charged, and the case comes to my office for prosecution. We review the charges. Sometimes we don't go forward with them if we believe that there's not been a crime committed or there is not sufficient probable cause to believe a crime has been committed, or the evidence is not sufficient. And those cases get dismissed. But if a case does go to court, we have the responsibility for putting that case together and presenting the evidence to the court. So that's kind of how the adult cases come in. We also have the occasion on our own to investigate and initiate investigations on our own. We also get citizen complaints, so we investigate sometimes. We also sometimes initiate charges on our own. But juvenile cases, which when I was thinking about this presentation, it dawned on me, people in school are not all juveniles. There are some adults. There are 18-year-olds in school, and we have handled some cases out of the Calvert County public school system involving 18-year-olds. Juveniles are any individuals under the age of 17, by the way. So if you're 18 and above, you're considered to be an adult in the state of Maryland, and the prosecution is handled in the adult court. Juvenile cases come to us in a completely different fashion. And I'm gonna ask April Brown to kind of give you all an overview of that process. And it's a little bit complicated, and it can be a little bit messy, but April's on top of it.
I'll start out with here that not all juveniles even fall within our jurisdiction of the cases that we can prosecute. There's kind of a tiered approach based on age in which we can actually go forward with a case at all, or have it even referred over to us. The base level is 13 years old, and that's the point in time in which we can go forward and charge for any sort of crime that may arise within the community and is brought to the attention of the Department of Juvenile Services. However, if you're under that 13-year age limit there, it becomes a little more nuanced of when we can actually go forward on a case. The next kind of grouping is this 10 to 12-year-old grouping. There's a select few charges that can occur for them. They're specific charges. They're crimes of violence has been the general one. And then as of the newest juvenile update, they've added in their aggravated animal cruelty, third-degree sex offense, and there's a few different gun crimes that also now fall under that as well. So that's if you're 10 to 12, and up here on the PowerPoint, this kind of explains what actually is a crime of violence. It's not always anything that you might think of has like a violent undertone. Second-degree assault, for one, is something people generally would think is a crime of violence. However, first-degree assault is the only one that really falls under that in terms of the assaults. So there are, as you can see there are a handful, there are a significant number of ones that we could go through, but that really they're the more serious of the crimes. Obviously, all crime is serious when it occurs with our juveniles, but these are I guess the top of those. And then if you go to the next slide, this is that new language there, which added crimes involving handguns and firearms, aggravated animal cruelty, and then sex offense in the third degree. That's newer to our ability to go forward on those. And then so I guess the last tier there would be that if you are under 10 years old, you cannot be charged with a crime at all. So that's really our elementary school aged kids, and some of the middle schoolers actually as well. The young middle schoolers, I think they pop up 6th grade sometimes. But for generally it's the elementary school. We don't see too much with that, but every once in a while something does come up in which we have to say, you're 9 years old, we cannot go forward, and that's just by legislature. That's what the law dictates right now. And so there is another subset of things in which we can charge, and to go forward here. And we kind of alluded that there are, I guess, this distinction between charging as a juvenile and charging as an adult. There are select cases in which a juvenile, meaning someone under the age of 18, starts out their case in the adult courts. And so this is under limited circumstances. Once again, under 14 years old, you'll see here you cannot be charged as an adult for any crime. So those you'd all be always charged as a new juvenile, no matter, I guess, really what's happening. The 14 and 15-year-olds is when you start to become eligible to be charged as an adult, and those are only offenses that carry the penalty of life in prison. It would be first-degree murder, first-degree rape. And when I say that when we can charge them as an adult, I will preface that to say that's where the charges start. There's a process in place in which, though they may be charged as an adult, their attorneys can ask that this still go back down to the juvenile system. So this is just where a case is originating and not where it's going to necessarily ultimately end up. But then I guess the next, once again, it's divided by ages here. In the 16 and 17-year-olds, they have specific crimes that are listed in which we can charge. I believe that we have an actual graphic on the next page here. So it's a few. It's once again, though all the crimes are serious, it's the top ones: the murders, rapes, first-degree assaults, carjackings, and firearms crimes, which they tend to occur. And so now I kind of wanted to touch base on how we even get these cases to start with. Because as we mentioned, in an adult court, when we get a case, or if it's a juvenile charged as an adult, that comes from the police, something happens in the community, it gets investigated, charged by them, and it's filed, and we see it in court. However, that's not the case with juveniles. Where these come from is DJS, the Department of Juvenile Services. So when a case happens, the officer forwards their complaint over to the Department of Juvenile Services, who then proceeds to have a review of the case. So on the onset, we do not initially see the cases. That goes to the Department of Juvenile Services. And they can choose, they have intakes sometimes with the actual juveniles and their families. But we could see it could close at intake. There could be pre-court diversion, and that's a period of 90 days that could then be extended. Or they could just then at that point choose to refer it over to us. Sometimes those referrals are asking for it to stay with them, but they need to have it referred over to us per statute. And other times they're just sending it over to us saying that, yes, we've reviewed this, we think a petition should be filed in juvenile court. And what those occur for are felony cases. Juveniles already under supervision of the department, that is new with the newest laws as well. And then traffic charges, but only if you're over 16. So if you're under 16 and you're driving without a license, you shouldn't even have one, those do not automatically come to us. And that's just how the legislature worded that one for whatever reason. But so when we get these cases, they're reviewed by DJS. I'll say the one caveat on that is if an officer requests detention and detention is sometimes granted, and by detention I mean sometimes it could just be community detention, so GPS or electronic monitoring, like an ankle monitor that's tracking you. We'll get those next day if it's granted. But that's still, it's reviewed by DJS on the onset to determine if they are going to grant that or not. It's not determined by our office. It's not initially seen by a judge. It's DJS who is called to determine that. And then the last way would be victim and officer appeals could come to our office as well. So that is if the Department of Juvenile Services declines to file a petition and closes the case out, either the victims or an officer can go and appeal that decision, and then it gets forwarded to us for review as well. So that's how we get a case. And then, so once we get it, there's a couple things that we can do. We can approve of whatever informal adjustment, like that's their pre-court, that 90-day period of pre-court, if that's requested of us. Even if it's not requested of us, we can choose to send the case back to the Department of Juvenile Services for informal supervision at that point. We could close it out for some reason and just, I guess, on review of this, decide it's not in the best interest of the juveniles and community to go forward on it at all and have no action. But in most of the cases, if it gets to us at this point, we'll file a petition in juvenile court. And once we file that petition, those options become, once again, on further review, if we could set it or send it back to DJS. So that's, if you've seen, it's an option at multiple levels. We could always wind up pausing this and sending it back. They could be put on probation. That would be either technically unsupervised, but most of the time supervised through the Department of Juvenile Services. They could be put on community detention, like I mentioned, those ankle monitors, or and the serious, I guess, intervention would be out-of-home placement. Within the newest laws here, they declined to allow misdemeanor out-of-home placements any longer, so that is only for felonies or we put a caveat of gun crimes. So those are, I guess, the options of what could happen, I guess, at the end of this. These are the things that we could ask the magistrate or the judge who is handling the case for in terms of dispositions in court. Because I think once again, when the difference between adults and juveniles is they're not found guilty of a crime, they're found involved of it. There's a completely different set of terms used for the trial is actually an adjudication. So it's completely different than the adult system. And the focus of it really, and our focus, yes, it is on the, community, but it is also on the rehabilitation of that juvenile and getting them the appropriate services through the department or the local care team, if they're consulted, because they frequently are by the Department of Juvenile Services, so that we can kind of stop this behavior and they don't have a future petition with us in juvenile court shortly down the line.
Okay.
Yeah.
So, I was just gonna follow up.
Go right ahead.
Go ahead. Well, I told you it was complicated, and it gets complicated moreover by the fact that the laws are changing rapidly every year. And they're kind of going back and forth. They swung one direction about 3 or 4 years ago. They're now starting to swing back a little bit more toward perhaps a consideration of public safety as opposed to simply rehabilitation. But the philosophy of the juvenile court and the juvenile justice system is completely different than it is for the adult court. Juvenile court, the primary focus is always about what's best in the best interest of the juvenile. Care and treatment is the primary goal. Adult court, it comes into play, but primarily adult court is more about public safety, protecting the community, and so there are many different consequences. Now, we gave you a long list of all the things that juveniles can be charged with as adults. Fortunately, here in Calvert County, I'd like to say we have, if not the lowest crime rate in the state of Maryland, one of the lowest crime rates in the state of Maryland. We do not have a whole lot of list of those crimes, juveniles being charged. Off the top of my head, April, I'm aware of one juvenile who was 17 years, 11 months, and 39 days or something, charged with an attempted murder that's in the adult court. As far as
I'll
any
say,
other,
we have 5 pending right now.
5.
That are under 17 being charged as an adult,
okay.
yes.
So it doesn't happen very often, but it does occasionally happen. Let me just comment on just a couple other things, and then we'll certainly like to entertain any questions. In addition to handling juvenile cases, juveniles who are alleged to have been involved in some criminal misconduct, we also prosecute truancy cases. In fact, Friday at 1 p.m. we have a truancy case on the docket for anyone who is interested in coming to. I had a meeting several months ago with my fellow state's attorneys, and Aisha Braveboy, who at the time was the state's attorney in Prince George's County, started talking about truancy cases, and she says, we're not finding out about kids who are not going to school until they haven't been in school for 6 months. And I'm like, oh my gosh. So I came back and I asked, what the situation was here, and discovered that sometimes it can be 30 to 60 days that a kid is missing school before we find out about their truancy. So we had an opportunity to sit down with the superintendent and his staff, and we have instituted procedures so that we don't wait that long before we get a truancy case started. We are now sending a letter, I guess we could call it a warning letter, to the parents. It's not really a warning, it's really outlining these are the things that can happen if your child it keeps missing school, can be prosecuted. And truancy cases, it's the parents who are prosecuted. The parents are prosecuted. They're brought into court in front of a judge and required to explain why their child is not attending school. And most of the time, a lot of the times, it's not because they don't want the kid to go to school. Sometimes the kid refuses to go. Other times there are other family issues and mental health issues that come into play. But we do handle those cases as well. We're also in the state's attorney's office not strictly reactive, we're proactive. We've attended the mock crash presentations at Huntingtown and Calvert high schools. We have outreach to the criminal justice students at each high school. We go out, we talk to them about criminal justice, and we've had meetings with the superintendent and his staff to facilitate the flow of information between the school system and the state's attorney's office, so that when we need to get information about something that might have happened in the schools, we don't have to go through a lengthy litigation process to get that information out. So, one other thing we do, which is pretty much unknown by everybody, whenever someone wants to file a charge against an educator, a teacher, someone in the school system, the state's attorney, namely me, has to actually review that and authorize that charge to go forward. So we've had a few of those over 5 years, 2 or 3, where teachers have been alleged to have frankly improperly pushed or shoved a student, and we have to look at that to see whether or not those cases should move forward. DJS, who is our partner in all of this that we work with, we work closely with school resource officers. I'm a huge supporter of school resource officers. We should have one in every school, middle school, elementary school, high school, every school. We work closely with them. They're sort of our eyes and ears in the schools. We rely on them very closely for information as to what's going on. Let me just say, by the way, we talk about the juvenile system. Most of the juvenile cases we don't ever see, do we? I mean, most of these cases are relatively minor cases that are closed at intake by juvenile. We don't get them. You know, so when you start talking about, oh, is there a lot of cannabis use in the schools? We generally, if someone is accused of that, we don't see it. We don't really know about it. And some of the other things. We do rely and work very closely with school resource officers to be our eyes and ears as to what's going on. The juvenile justice system is changing very rapidly. We were at the Ocean last week for Maryland State's Attorneys' summer conference. While we were there, we had an opportunity to meet with the governor and his public safety staff. And we had an opportunity to express our concerns about the juvenile justice system. Juvenile justice in Maryland for many, many years, predating this governor, predating the head of juvenile services, had been a big mess. There's not enough resources, not enough staff, not enough programs, not enough anything. Juvenile justice reminds me of somebody who goes to the fried chicken dinner and loads up their plate with fried chicken and macaroni and cheese and all of this, and gets this huge plate and then looks at it and says, what am I supposed to do with this? I can't eat all this. Juvenile is the same way. They want to have this huge plate. They want to be able to provide, but they don't have the resources to provide. So we made that point to the governor, and I think the governor was listening. There are a couple of things on the horizon. One of them is something called direct file, meaning that no cases against a juvenile would ever start in adult court. They would all go to juvenile, and if the case was serious enough, it could be brought up to adult court. That's on the horizon. Probably won't get through. Tried to get it through last year and the year before, it didn't get through. Probably won't get through next year because it's election year. Year after next, direct file will probably be a thing. The other thing that's important is detention hearings. Juveniles are being charged specifically in Baltimore City, out of control, carjackings left and right, robberies left and right. State's Attorney Ivan Bates up there says they have 131 juveniles arrested for violent felonies, and DJS lets all of them out except for maybe 20. So that is a real problem. We're pushing to get a change at DJS where for violent felonies and gun crimes, juveniles would have to go in front of a judge or a magistrate in order to be released. It wouldn't be up to DJS to just say, you can go home. They were sending people home on home detention, home monitoring, and saying come back tomorrow, and they weren't coming back. So those points have been made. That's what's on the horizon, and that's what's going on with DJS. Mr. Schiraldi is out. There's a new DJS department head, and we're hoping that we're going to be able to work well with her. Thank you.
Thank you. Go right ahead.
I think you briefly spoke about this. Maryland has the unfortunate recognition of incarcerating more juveniles than any other state in the nation. What is Calvert rate of incarceration in comparisons to the other counties in the state?
You're talking about juveniles who are
Juveniles.
detained. We don't incarcerate juveniles, we detain them.
Okay.
Okay.
I will
Do we
say-
have any?
We do have, one that was placed on, community detention.
Mm-hmm.
I'm trying to think, I don't, outside, I will say this is outside of
Oops.
those few that are charged as an adults. I'm talking about the kids who are being charged as juveniles right now, because we do have those 5 kids that are charged as an adults. I believe those are being detained. But in terms of our juveniles, I can only think of one, and it's community detention. I don't believe we have anyone in pre-court detention right now, and that would be, our local one would be Cheltenham, where most of them go. Though that's not the only one. They could also go to, theoretically, any detention facility within the state if they were to be detained. But no, it's Calvert counties is very low compared to the other counties across the state.
Yeah, and that, I think my other question would be, and I think you just spoke about it, is that the other concern is that many times the juveniles are placed with adults, but when they're detained, but you're saying they would go to Cheltenham, is that correct?
I would say, yeah, when you are charged as a juvenile, you are not being placed in general population at the detention center. You are going to a facility, and like I said, it would be Cheltenham, but it could be Hickey, that's over in Baltimore. There's one in Western Maryland, there's one on Eastern Shore. And those are just solely, they're youth facilities. That's where our juveniles would go. Now, in the case of a juvenile that's charged as an adult, that is not always the case. But I will say that in terms of Calvert County, it's the judge's discretion, really, as to if they go to a juvenile facility or stay in an adult facility, and there's a series of factors that they would have to consider. I believe the judges are generally, what the trend I see is sending them to Cheltenham until it is determined for sure that they're going to be charged as an adult, and that's after there's the transfer process.
Yeah, I think, in my experience, juveniles who are charged as adults with crimes such as first-degree assault, attempted murder, are detained, if they are detained, which they generally are because of the seriousness of the crime, they are detained at a juvenile facility, such as Cheltenham, until such time as it is determined after a hearing that the case is going to go to adult court. Once they're determined that it's going to be an adult court, then it's my understanding they're then put at the detention center, just like anybody else, any other adult.
Thank you.
Any other questions?
Have we had any cases of juveniles being used to commit crimes on behalf of adult crime networks, or anything that, on behalf of other adults, I should say?
We have cases sometimes where there's a juvenile and they have adult co-defendants. So yeah, they're sometimes working in connection. And we see this especially if they're 17-year-olds having 18 or 19-year-old associates that they're working, in tandem with. I'll say it's not been my experience where I've seen it where it's like older adults that are kind of having these younger adults commit the crimes, but it's more so all these young people right on the verge of that adult juvenile line that are working in tandem together.
Yeah, I think you might be referring to some of the anecdotal evidence out of Baltimore City, where adults are supposedly using juveniles to carjack vehicles. We don't have carjackings. Crossing my fingers every time I say something like that. One of them pops up, but we don't have carjackings here in Calvert County, or at least we haven't had one in recent memory, and certainly nothing committed by juveniles.
I just wanted to share, just as a point of information, that I serve on the Juvenile Services Education Program Board appointed by Governor Westmore, so I'll be down at the office getting sworn in for another 5-year term, so FYI.
Congratulations. That's great. It's great to have a voice from
Sure.
Calvert County, really is.
Before we move on, I have a question. Both Ms. Brown and Ms. Odom referred to out-of-home placements. Okay. In Ms. Odom's presentation, you made reference to the family, quote, voluntarily, meaning they don't lose custody, and that there's an assessment process to determine their ability to assist for the payment. Okay. When there's a gap or when they can't, who pays?
The state,
The state of Maryland.
yes.
From what source?
So it's a long, lengthy process, and I'm one of those gatekeepers, as I described. We were created, local care teams were created so that we would limit how much money the state was spending on these out-of-home placements. That includes those DJS, that includes those DSS, the school, and mental health. After the community resources have been exhausted, each of those agencies still have a process that they have to go through at the state level before it can be approved for the funding. So the funding comes out of the Governor's Office for Children, Youth, and Families.
Okay, so it comes out of the Governor's Office for Children, Youth, and Families. And so there's evidently a pool of resources, some designated for education, some designated for other purposes, that all lump together to provide for this out-of-home placement.
Yes, it is a dual cost.
Okay, so, all right, so it's not a charge directly to the local school board.
The school board component is if the child is in a level 5 non-public school, it means that they have to pay for their education wherever they're at.
All right, so
If they get placed
the
out of
child
home, they still pay.
Is the child is deemed level 5, meaning special needs, at a higher end, then the local school board bears 100% of the cost?
Of the educational component.
Of the educational component.
And at that point, the mental health component of living at that facility, after 30 days, is paid through medical assistance.
Okay, so the health component is medical assistance. And that would be Medicaid,
Yes.
that we hear is gonna be butchered.
Yes.
Okay, and, okay, so then Medicaid pays for the residential cost?
Yes.
Okay. What, okay, does Medicaid then also pay for the mental health or any other support?
That's part of the residential part.
Okay,
Mhm.
okay, all right. So when you say dual, then what you're referring to then is Medicaid and local school section for education?
Yes.
Okay. Ms. Brown?
Yes, and I'll say, though she said our placements might fall under theirs, I use that term slightly differently, because I use it in the context of when an out-of-home placement for a youth is ordered, it is a program, and that is like, it's essentially, because we do not incarcerate.
Mhm.
So at the disposition stage, the sentencing stage, if they are deemed, they need the additional heightened services, then they go to a facility where it's a program. Most of them are like steps, like you're step 1 and then you graduate to step 2, where they learn different skills, and they do have those resources, mental health resources and school resources, but it is something that it would be ordered by the court for them to attend. So this is not a voluntary placement by their family. At this point, I guess they've graduated beyond that and are needing to be told by the court system they have to go here.
Now, who pays for that?
I'm unaware, I don't know if she,
Maryland Governor's Office of Children, Youth, and Families. It's the same entity.
Same formula?
Yes.
Same formula.
Yes.
So
So that would be like a description she gave of a group home. I refer to the residential treatment centers. I also refer to the diagnostic centers. There are other entities out of home.
Okay, so what happens if they go to what you call community, Cheltenham or Hickey? Same
Well,
kind?
those are typically pre-court youth facilities, holding facilities prior to it. So if if an out-of-home placement is ordered, there's some other ones, I guess the most secure and well-known is Victor Cullen, which is a hardware secure facility, meaning, I guess there's additional restrictions on the child's movement. But they're like it tends to be, in my experience, a couple-month program. But then if a youth gets kicked out of that program, then they go and search and put them in another program. And quite frankly, if they've exhausted the Maryland resources, we look out of state. So it could be really anywhere in the US. I know in the past we've had to go to Tennessee and go to Florida for some of our youth.
Yeah.
So I don't know the specifics of the funding, where it comes for, because quite frankly, we recommend it, but I don't ever see that side of things.
Yeah, we recommend it, we don't pay for it.
Yeah.
You know, Hickey, Cheltenham, Victor Cullen, those are all DJS facilities. I mean,
Yes.
State of Maryland is paying for that.
Mhm.
Now, there are programs outside of those community-based programs. I'm pretty sure, I think, that DJS is paying on a contract basis for that as well.
Okay.
They are, and they're paying handsomely. And they have to pay for transportation to allow that family to have visitation with them. And so, of course, those are the type of placements that they want to avoid.
Okay, well, in my humble opinion, they ought to be paying more. We need more. One of the problems is we try to refer people to programs to get the services they need, and they have to wait. So you can only be on juvenile probation for a set period of time. It's not very long anymore. So by the time you get yourself into one of these programs, you've already expended half of your probationary period, and the program is over before by the time your probation is over, the program, you're still in the program. You haven't finished the program.
So you haven't finished the program, and then based upon the research and whatever cost you to enter it, it may mean that the behavior isn't modified either. And so-
Exactly. Remember what I said about the fried chicken dinner?
Mhm.
Okay, they want to pile up the plate, but they don't know what to do with it after it's on the plate. You've got to be able. We all love our children. Ivan Bates, State's Attorney, Baltimore City, says, number one, we got to remember we love our children. They're our future. You want to take care of the problem, you've got to be able to provide the services and the programs. Doesn't do any good to just detain somebody. I don't want to wreck a kid's life for the rest of his life, 16, 17 years old. I don't want to do that. I want to get these kids on the right track. But you gotta pay. You gotta pay to do it.
Does DJS still do groups? So like anger management and victim awareness?
Yes, that's something that we see
Restorative
in
practices.
probation.
Restorative practices, yeah.
We see the victim awareness classes, they're frequently a part of probation for our juveniles. And they have other programs as well.
Are there wait lists for those, or are they usually able to get in earlier in the process? Like, we know for some programs like IHIP, the in-home behavioral interventions, that they're for Medicaid only, so that limits it, and that there is a wait because they're just not built out to support the whole county. But
I would say that where I see the biggest waste is in the mental health.
yeah,
And the therapies and the substance abuse treatment. In terms of the smaller programs, we have done the Mothers Against Drunk Driving, victim awareness, anger management. Those tend to be quick turnaround
immediate.
times. Yeah.
Okay, that's helpful.
Okay. Any other questions?
Leslie, Jason, do you have any questions?
No, ma'am, but thank you.
Please.
I do not. I just want to take a minute to say how much I appreciate you guys coming in today. I think this is a really important piece about educating our community. I'm kind of a big proponent of that, making sure that parents understand the process, what can happen, what's available. And you guys have done a great job today making sure that we're getting that information out to the people that need it. So thank you so much.
All right. Good afternoon. For those that don't know me, my name is Justin Sasser. I am the family and juvenile magistrate. I have the honor of serving in that capacity starting about 18 months ago. Before that, you may have known Magistrate McCurgan had served in that role for 18 years prior to me, so I have some big shoes to fill. But prior to that, my experience has been that I have been a family law practitioner private the last 30 years prior to that, so I do have a little bit of experience in this area with regards to both issues concerning the best interest of children. There we go. Best interest of children in and out of the juvenile justice system. As Mr. Harvey had indicated, there has been within the last 4 or 5 years sea changes in juvenile justice. Starting back in 2019, before that time we didn't have an age limit. You could have a child of any age come before the juvenile justice system. At that point in time, there was a focus change, a paradigm change, so to speak. And at that time, the focus of the juvenile justice system was changed from penal, a consequence, to more of a rehabilitative or a balance, more weighing of safety both for the juvenile and the public, as well as trying to curtail whatever alleged activities that the juvenile was conducting at the time, whether that be something that was very serious or something not as serious in the range of offenses that could be brought before the juvenile justice system. In 2022, there was a huge pendulum swing in the other direction when there was a limit to the age limit that the children could come in front of, the juveniles could come in front of the court to 13 or above. So at that point, and we saw a lot of the headlines and the press, particularly out of some of the more populous jurisdictions wherein there were a lot of juveniles that were under that age that simply could not be charged, could not come before the juvenile justice system. It was something that was not available to the state's attorney, or they couldn't come before the Department of Juvenile Services. They were just something that you could not, well, potentially before the Department of Juvenile Services, but not necessarily before the juvenile justice system. When I took my seat at the table, I did so at this end because in the range of things, I am the end of the road. So I am the sharp end of the stick when you're talking about what starts. Unfortunately, Department of Juvenile Services hasn't been here because you have to understand, in our system, a lot of times, by the time it gets to me, the juvenile has had an opportunity, and I use that term loosely, an opportunity, to come in contact with law enforcement, at which point in time, law enforcement makes a determination as to, is this something that I need to address or not? Is this something that I need to bring to Department of Juvenile Services or not? So there's a vetting at that point in time. Is this serious enough, or is this young people doing stupid things that don't necessarily need to be charged? At that point, if it is, it gets referred to the Department of Juvenile Services, or there's a petition that comes up, and Department of Juvenile Services would be at different seats throughout this. Obviously, they can start. They're in the middle, where they work with the state's attorney to make a determination as to whether they're going to handle the matter in-house. And some of the law changes have changed there because there was some concern that at the Department of Juvenile Services had too much authority to make a determination as to the appropriate way to handle this, whether it should be in-house or whether it should be by producing charges that were going to be forwarded to the state's attorney. So that's the second level at which the juvenile has a contact with the system, and they have a range of services, and I can't speak for them, but they have a range of services that are available to the juvenile and their families to address issues short of having to bring charges formally and put them through the juvenile justice system as it comes to me. Then, if it is, it gets referred to the state's attorney's office, and you've already heard from them with regards to what they do. So they have a vetting process to determine whether it's appropriate to file charges and bring charges with that juvenile in front of me through the court system. And the court system, so you know where I sit, my authority comes from the judges of this circuit court, the circuit court for Calvert County. Specifically, I'm a magistrate, so my authority only lies within what they authorize me to do. In this instance, I'm authorized to hear family law cases and juvenile cases. In different jurisdictions, you might be aware, magistrates serve in different capacities. There are foreclosure magistrates that only handle foreclosure matters. There are magistrates, particularly in larger jurisdictions like Prince George's County, they are authorized the same as me, but they are very much more detailed. There is a magistrate that only handles family cases, a magistrate that only handles juvenile cases, a magistrate that only handles juvenile SENA matters, child in need of assistance. So depending upon the need of the county and the resources available, you'll find a magistrate that serves in that capacity. For Calvert County, I'm it with regards to both family and juvenile matters. So most of the matters that are going to come before me are the juvenile matters that aren't of a serious nature where they're going to be charged as adults and brought before a circuit court judge. In those serious crimes that Ms. Brown has mentioned and Mr. Harvey's mentioned, those cases are not going to generally come before me unless, of course, there's a law change where all matters have to be vetted by a magistrate at the juvenile justice system level, I mean the entry level, and make a determination as to whether they're going to waive up as opposed to be charged. And that's a whole different process as it exists now. But with regards to where I am in the system, I'm going to see a majority of what Calvert County juveniles are going to encounter when it gets that far. So like I said, I'm at the end of the road, but they've had 4 or 5 bites at the apple as to diversionary services that are available to them so that it doesn't get to the serious business of an adjudication. And again, the languages are different, and it's specifically, again, the authority that the circuit court has is under an entirely different article of the Maryland Code than is the criminal prosecutions. So that's on purpose. There is an entirely different set of rules and a different focus on what it is that we're trying to accomplish. It's not just cause and effect. It's just not just consequences if you're found to be guilty as an adult. If you're found to be involved of a juvenile delinquent act, then that's where the disposition phase of that comes in. Basically, they come in front of me. There's 3 phases. First, they come in along with their adult guardian, whether that be their parent or whomever has juvenile, who has authority over the juvenile. And the adult is also required to show up. If they do not show up or assist the juvenile in showing up, then a bench warrant, a body attachment can be issued for them so that I can compel them to bring them in front of me. So it is when it gets to me, it is of a serious matter, and for adults as well. I say that because adults do have some skin in the game, even if you have a parent or adult guardian that doesn't necessarily want to be part of it, they can be compelled and be made a part of it. And they do have some exposure to liability because if there's damages or restitution ordered, they can be on the hook for that as well. But first of all, we advise them of their rights, and there's a process for that. But the juvenile process, you have to understand, is a little bit more fast-tracked with the thought of if they are for some reason being detained or placed out of home, we want to get them in front of the court as soon as possible. So the due process is a lot more expedited in a juvenile matter. 60 days from the date that they're served, they're coming in front of me on a adjudication, a hearing. If everybody in adult speak, that'd be a trial. At that, so that moves a lot quicker than our normal, even a district court moves generally a lot quicker than any of the other adult criminal proceedings. And there's a purpose for that, because if there has to be a detention, there is a whole raft of things that have to be considered in the interim until that child gets their adjudication. So my docket is consistently filled with things where not just, okay, now they've been charged and we're gonna have something in 60 days. Sometimes I will see them, particularly if they are being detained, I'll see them every 14 to 15 days in front of me for a hearing to determine whether it's appropriate to keep them at that point in time. Because it's serious, in the lay of things, it's serious to keep them detained. The thought is that they are better served being at home and receiving potentially services leading up to their adjudication, weighed and balanced with safety of the juvenile and the general public versus the need to keep them detained and make sure that they face the adjudication that they've now been charged with, to adjudicate the charges they've been charged with. So at that point, then we'll have an adjudication. There's a determination made by me or a judge if it's appropriate. And at that point in time, then they are found either not involved or involved of any of the charges that have been brought. The charges are going to sound exactly like you would hear in a criminal matter because they, by definition in the statute, if you were an adult and facing these charges, they would be crimes. So the criminal code is the same, it's just that they're going to be handled in a different posture, a different manner. So the standard of proof is the same, beyond reasonable doubt, a hearing is conducted, and if they are found involved of whatever count or counts that are involved, then we move on to the disposition of that. The disposition is going to involve sentencing in adult speak. And that's really where I think you might find the most questions you may have for me, because I have a wide range of ability, though it has been more limited in recent years as to what I can do to address a juvenile that has been found involved of committing a juvenile delinquent act. As Ms. Brown stated, with regards to misdemeanor charges, unless they are of a certain nature, there is not an ability generally to detain them and put them in a care facility or it depends again, on the nature of what it is, but generally that's not an option for us. So we're looking at something in the nature of probation, and whether that's going to be supervised probation, that's generally going to be with and under the supervision of their parent or guardian. And at that time, there's a range of things depending upon what they've been found involved with regards to whether they need mental health services, whether they need substance abuse counseling, whether they need anger management issues, whether they need victim awareness, whether they need just simply community service. Because if you come in front of me and you've been found involved, not only are you going to get the services, but there is going to be some punitive effect. And what a young person has to give is their time. So their time becomes my time. And you will give me my time. And if I tell you that you owe me 40 hours, you're not completing your supervised probation until you've given me my 40 hours. And those hours can be selected and performed anywhere you need to that accepts that. And a lot of times there are endless organizations that are available to provide that. Along the way, sometimes we find that sometimes the issues are more so organic to issues that are coming from their parents or guardians. And their parents or guardians may need some assistance and services as well. And I do have the authority to compel the adult to participate in certain things. So that, for instance, if there needs to be family counseling or something to that effect, because there's a real rub between the juvenile and the adult, the parent, then sometimes the best medicine is to get them both in a room and address that. Or maybe there's substance abuse issues with both the adult and the juvenile. And maybe it's stemming from the fact that the adult is providing the juvenile with the substances that they're potentially using. So those are all things that are available to me. If it is of a more serious nature, I can certainly detain them if I find that they are on a flight risk or they are a danger to themselves or others. Generally, that's pre-adjudication. If there is a serious nature and there is a an ability to, I can place them, and there are other facilities other than DJS facilities. So there's both DJS facilities, which you're familiar with, Cheltenham and Victor Cullen. Some of them are more secure facilities than others. But again, sometimes you'll find that I order these things and there's just not bed space within the state. So they get I've got somebody in Calvert that's farmed up in Baltimore, or sometimes I got one that's in West Virginia. I mean, sometimes it happens that way. The order comes down, and Department of Juvenile Services does their best to try to implement, and that's where DJS would be sitting on this side of me at the other end, because after I have ordered whatever it is that I find appropriate to address the root cause of the juvenile's delinquency, DJS is the one that has to implement that plan and has to try to find the resources, and sometimes they have it in-house, and sometimes they do not. And sometimes if they have it in-house, they simply might not have the resources available to them at that time. And that was the issue that Mr. Harvey was bringing up, is that there is a finite amount of time. It's now been expanded just recently from 6 months to a year, where we can keep them on that supervised probation. But if it can't get done in that period of time, it's not getting done, unless there is some pervading fact that can allow us under the current statute to extend that period. But there has to be a case made, and it's not a foregone conclusion. Even if the services are taking effect, sometimes you have a recalcitrant child. It just takes a little bit more convincing that you're not getting out of this unless you do what is asked of you. And sometimes it takes them longer to come to that conclusion than others. And we can see some positive progress being made, but at the end of the day, services terminate when the law says services terminate, because they cannot be kept any longer. And that's the ebb and flow of what we see every day that comes before me. We do the best we can to try to address, try to drill down and find out what services are needed based upon what are we hearing here. Is this just a child that did something stupid one-off, or is this a child that has a pattern? And if there's a pattern, what's the root cause of it? And sometimes it's a difficult thing to see from my vantage to begin with, and it takes some time to try to figure that out through services that might otherwise be provided. But again, we have to work within the structure that we're given.
Thank you. I would be remiss if I did not try to get to the bottom of this. How many juveniles do you take through your process a year in Calvert? And how has that trend looked over your 18 months?
Sure. So I don't have the exact numbers, but I can tell you just in preparing to take over this role and having an opportunity, graciously, Magistrate McGurgan was able to share some of her wisdom and what she had over the last 18 years. Particularly prior to 2022, there was a lot more juvenile prosecution at that point in time. Calvert, fortunately, is not a jurisdiction that has a lot of juvenile infractions, but since 2022, if you can't put a juvenile in detention for the charge of almost all misdemeanors, there's not a whole lot that's coming through. So the volume that I have seen has been fairly steady, but it is markedly decreased. And the only source that I had from that is Magistrate McGurgan's letting me know of what her dockets look like, as opposed to her old dockets look like before 22 versus what they look like after 22. I came on in the very end of 23. So what I've seen is fairly static. And most of the crimes that I'm seeing, most of the juvenile offenses that I'm seeing are fortunately not those of violent crimes. Malicious destruction of property, school fights that result in second-degree assault charges, some things of that nature. Again, with the change, sometimes, a lot of times what will happen is that you'll find that there are substance abuse issues involved in that, but they're not being charged with that because based upon the change in law and the attitude towards cannabis use, there's less, but I view that, I mean, for instance, there are situations where a juvenile might come in front of you and want to enter a plea, and they're represented by the public defender or private counsel, and they come in there and they tell me they're under the influence. Well, I can't take their plea, and then I know that there's a substance abuse issue. Because if they're coming to court, if they're coming to court in the custody of their adult and they're under the influence such that I can't even adjudicate them because they're under the influence, then I know that's an issue, and then we have to address that.
Is it 100 a year and 24 or less?
Numbers of so you're talking about each one being separate, because each juvenile could come in front of me, many times throughout the course of
I
the year.
understand
If
that.
you're talking about initial filings, I would say probably at least 100.
Okay.
The state's attorney might have better numbers on
All
that.
right,
say
and
the
they might
ones
have
that are
multiple
bringing the
offenses
the charges.
Those charges, okay. All right. Ms. Brown,
Yes?
how many come to you and how many you send back to DGS?
I don't have the exact numbers on those. I will say that, there's a lot that stay with DJS that I don't even see. So, for me to even get to them, they're probably have some sort of felony or they've been with them multiple times. So I will say majority of the stuff that comes to me, I'm going to be filing a petition on it just because by nature of it, DJS has reviewed it. They've determined for whatever reason that, they're not eligible or for pre-court services or, the crime is such of a nature that they're not doing that. There's been a couple. It's honestly, it's probably been a handful that
Okay.
I've sent back. Cause every once in a while, one will come through. I think it's, where, after review of it, really we can resolve it back with them.
Okay.
There's been a couple where restitution has been an issue and it just takes a phone call up and, working out a plan. But, by and large, they're, if they're coming to me, they're getting a petition filed because we get so few.
Okay.
Yeah.
I've reached the stage in my tenure that the elephants have to come out. And so we've been kind and gentle throughout the first 9 months of this. So I have a couple elephant questions. One is, how many juveniles are we taking through this process? And the real question is, were they acting in the capacity or whatever they were carrying out as students at that time, or were they away from school? Because one of the things that I keeps getting referenced is how many times the school system turns people over or suggested they be arrested. But I would submit to you that, most people don't realize this, but 85% of our time between the ages of 6 and 18, we're not in school. So when is this behavior occurring? And are they students acting in school for this, or are they away from school?
And yet, I will say that, by and large, the things that I see coming from the school are the second-degree assaults and the malicious destruction of property. I'll say we do have a robbery. There's always, an occasional thing that pops up at the school. But, by and large, I will say that they are, away from the school.
Away from the
For
school.
the ones that we get. And I will say that I don't know what I don't know. So, we've recently have some increased communication where we're getting, now the reports from, the schools, and they're letting us know when an incident occurs. But that's from it's from the SRO, the school resource officers. So our counterparts over at, in law enforcement. But if it's not reported to them and charges are not filed, with the school, then I don't know about it at all. So really, there could be a lot more there that I don't know about it. I don't know if, that would have to come from our school board, I think.
Pastor Jones, I share your frustration. One of the real problems that I experience is really a lack of understanding as to what's going on with our juveniles in school and out of school. I really formed the belief that DJS was playing what I call hide the ball, which is if we don't refer it to the state's attorney's office and they don't know about it, it didn't really happen. And that's one of the things that across the state we've communicated to the governor. I think it may have been one of the reasons why there's been a change at the top, because I think the philosophy that you see in the local counties here, and by the way, we have an excellent working relationship with the people working here at DJS in Calvert County. But the philosophy is trickling down from the top. And the philosophy, in my opinion, was if we don't report it, it didn't happen. And now we can say that juvenile crime is going down and we don't have a problem. And of course we know differently, at least they certainly know it in Baltimore City because they've got juvenile crime out of control, carjackings and robberies. We don't have that here, but I still feel the same way, that we don't have the information. And I'm hoping that we're going to get that kind of communication with the new director.
Yeah, because for some reason, as I've said in this chair, it seems as if there's this perception that everything that goes wrong with a child between the ages of 5 and 18 is the fault of the school system. And there's just this reality about this community and all the opportunities we have to get it right and to get it wrong. And it all doesn't exist or function exclusively during the school day. And so as I've listened to multiple presentations now, I'm convinced that there are gaps and things that aren't being said that somebody has to ask a question about, because I don't quite get it. One of the things that I got from a prior conversation with some DGS folks was, and you alluded to it, when you spoke about the children being basically remanded back to their parents, given that responsibility. What kind of support system is there for parents with children who are out of control, for lack of better terms? I mean, that's a Dana Jones term. Blame that on me. I'm sure there's some professional language that Ms. Odoms can give me, but it.
From where I sit, which is at, again, the end of the road, there are different ways it can come in front of me. So there is a juvenile delinquency petition. There is a child in need of services petition, which is a little bit different than a juvenile delinquency petition, and that would be somewhere along the lines of the child there, and it's not a child in need of assistance, which is abuse or neglect. It's not that, and it's not that the child is otherwise breaking laws, but they're just unruly at home. And that would kind of, and this is somewhat of a new thing that they've put in the code, which regards to child in need of services, but there's not a whole lot of teeth in that. For instance, it is something that provides and opens up, if you're found child in need of services, that services become available that would not otherwise be available, but there's very little ability to really get a juvenile's attention. In other words, put them on electronic monitoring or put them in and detain them as a SINS. And that's not the focus of SINS, but sometimes, they're trying to address an issue, what you said, which is in between. They're not being abused or neglected. Base needs are being met, and they're not committing juvenile delinquent acts that would rise to the level of being charged, but there's still a problem. And sometimes that is just that they're having issues with the adult in their home, and they're going through that phase or whatever that may be. Maybe there are issues with regards to maturity or mental health issues that have yet to be diagnosed. I mean, it's very difficult to assess and get an accurate assessment of what a root cause is with regards to mental health services with a young child who's developing and changing through their adolescence. I mean, you know, sometimes it's just not pleasant people. That doesn't mean that there's a diagnosable things that needs to be addressed. It just means that there's a change going on. So it's sort of hard, and that's what was put in place to try to address that tweener. But again, it's relatively new within the panoply of things that we've had for years. And it's sort of in its infancy, and we're trying to figure out how we can navigate that better.
For lack of a better way of putting it, oftentimes children's problems are parents' problems, right? In many ways, whether it be genetically, environmentally, etc. So the parenting workshops and resources are always underutilized. Yet when the children begin to act out and the parents have consequences, then it's, oh, I'm the problem? What can I do? So we have resources that we've put out there that are underutilized by parents. We have the 3 Ps program that we started. We have community mediation programs that are underutilized. And oftentimes in environments like this, we want to know where should the resources go to help this overall problem, right? So your question was about how often are these acts committed in school that get them down this line, and how often are they in the community? We are sitting in a building that we so want to have to be a community resource. We want to have an environment where children can go, participate, socialize, learn new things, etc. It's going to take a lot of money to build the one we really wanted, right? And at the same time, the first part of your question is whether or not it's at school. So do the resources go to a school resource officer in every school? Do we need more police at the school? Do we need more police involvement? Do we need more programming in the school? And the answer is we need it all, because there is no one answer that's going to resolve or solve all of the different reasons why children get here. But we want the biggest bang for our buck.
I couldn't agree with you more. My only question is then how do we increase the utilization of the parenting piece? Because the other professionals who aren't present have indicated that we have stressed parents who need a support system that doesn't exist. And quite honestly, you know, there's the late Senator Jim Simpson used to say all the time that if the General Assembly didn't meet, the state of Maryland would be much better off. But each time that the General Assembly meets, what I hear is a wish list with no money, okay, and then, you know, I'm hearing we need it all. Yes, and I'm not disagreeing with you. I'm just simply saying somewhere along the lines there has to be a system that matches the expectations with the resources, and at the same time a focus on strengthening families. Because, you know, I know I'm older than dirt, but my father had a cure for all of this. Okay. And you know, and I heard things like you will not be a burden to this state, which meant that, you know.
Or an embarrassment to your family.
Exactly. Yeah, and so in the midst of all of that, I understand that these are different times and the environments are completely different, you know. So in looking at where we are, I guess the question I'll leave you with is how can we strengthen the use of our parenting and family support systems?
do you have the same list that, like, say, DJS has for those diversionary programs for parenting and support programs? Does the courts, do they have, those lists mirror each other? So let's say, okay, there wasn't the teeth in the diversion, right? So then they make their way up the chain again, and they come to you, but you come with enforcement, whereas DJS really, they don't come with the same level of enforcement. So, like, could that be reapplied, that same recommendation, or is your list smaller?
Well, as far as their diversionary, I mean, so mine is probably a subset of what theirs is initially, but their focus initially is to try to keep them away from having to face me.
Yeah.
I understand.
So what they have available to them, and again, I can't speak for them, but what they have available to them and the influence is you don't wanna have to go down that road, because down that road are only consequences if you're
Right.
found involved. So I'm offering you something that's less painful. It's gonna be painful, but less painful than what you might otherwise encounter if you have to go the distance, because if you do, consequences.
Right.
So that, I mean, but DJS usually has, and when I ask if there's something outside of what the norm would be, because I see a need that potentially could be addressed that might fix the problem, they will do their best if they don't have it in their quiver, so to speak, if they don't have it within them, to find it. And that's where other resources come in, and they're very diligent at trying to find those things. But again, at the end of the day, I only have what I have. And if it's
Yeah.
not, and even if they say it's available, it might be, again, a matter of pragmatic. It's available, but it's not available for 3 or 4 months. Maybe that's the best medicine here, but is it effective? If I'm gonna have X number of months to try to address this issue and try to get this juvenile back on track, I can't go on a wing and a prayer. I gotta take what's in front of me at the moment and hope for the best.
Yeah.
And that's unfortunately what I have to deal with. I have to use, if I don't have the penicillin, I can't
Yeah.
use the penicillin.
Yeah.
Can't
You know,
prescri- I
it's-
can't prescribe it.
Yeah, I hear what you're saying, and I believe we need the resources. I would argue that the reason that we even came into existence is because there's an environmental change with regard to young people's behavior, and evolving legislative process that seems to try to be figuring out some things, and yet a community perception and philosophy that I would submit that historically is counter to all of what you described to us today. And so part of what we're dealing with is trying to figure out, in this little place that a lot of folks hold sacred called Calvert, what's the best way? We don't have massive problems, okay? But what's the best way to get to the place that we want to be in terms of strengthening and supporting families such that they don't come to see you? We don't want people to come see you.
I would prefer my doctor to
Yeah.
be very likely.
Yeah, and so that's, I think that's part of what our charge is. And so, open to any suggestions that you offer later on, now or later.
Well, you posed an excellent question, but I don't know that we have the answer. That's the problem.
Yeah,
I mean, you're exactly right. When I was a kid, we didn't have to worry about DJS. My parents took care of it all.
yeah,
Problem was taken, I never made it to DJS.
no.
Taken care of in the house.
Mhm. Yeah, different world, different time.
Yep.
And so we understand that. And then the other thing too is that, let's be real. We came up in times, I can remember when we got our first television. Okay, and not everybody walked around with a phone, and there certainly wasn't anything called social media. So in the midst of all of that, I realized that part of our problem is, at least in those of us who are older, is that the world is radically different. But our responsibilities as a community are still as important to keep not just a safe environment, but an environment where young people can flourish. I mean, you know, I don't lose sleep about public safety in Calvert County, but I do lose.
Well, I do.
I lose sleep about what I see happening to our young people. I mean, that's what bothers me. I just think that we need to look differently.
Can I just ask a clarifying question for all of you on the panel? Most of you have alluded to the fact that family involvement is necessary as part of your process. But there's a difference between involvement and engagement. So can you speak a little bit about that? Because to Ms. Odom's point, we have a lot of resources within the county, but a lot of those are underutilized, or there's a frustration on the part of, if the first resource isn't available, we don't go to the second or third. So can you talk about the engagement of families, because sometimes families of origin are sometimes part of the issue, to getting them the necessary services. So even if you were to order someone to do the services or to engage in things, follow-up, unfortunately for youth is difficult if they don't have support coming from home. So can you just kind of briefly speak a little bit about the engagement piece?
There's definitely, I mean, if they've gotten to the point where we're filing a petition and it's coming before Magistrate Sasser, then, you know, there's some issues. A lot of time it is within the family. I've seen before where we have reluctant parents who aren't engaged in getting their child the services that we deem they need, even on probation, and DJS has been there. I will say they're not here to advocate for themselves, but DJS is a resource in that, and getting the kids the resources in that situation, because they can make phone calls. They can go help set up appointments and things. And when all breaks down, we've had to have, on occasion, while they're in court, pulling out their phones and making that appointment that we said that they were supposed to make between now and then. So there's definitely, you know, it's part of the problem, the breakdown in the family and them not being as engaged as they should. If that's leading to the problem, we try the best we can, but it's definitely, you know, we only can do what we can. Yeah.
Okay, any other questions? You guys have been invaluable. We thank you for your presentations, and thank you for at least entertaining our questions and wrestling with some of the issues that you wrestled with. And thank you for your public service. I mean, you do a phenomenal job, and you're one of the reasons this is the place that people love to be. Thank you.
Thank you.
Thank you all.
Thank you.
Have a great afternoon. Ready? Ooh.
We have reached the section of our meeting that is for public comment. Do we have any public comments?
If you wish to leave public comment and you're joining us online, please use the raise your hand function now to leave public comment. Again, if you wish to leave public comment and you're joining us via Zoom, please use the raise your hand function now. Mr. Chair, no public comment today. Thank you.
Well, thank you there. With no public comments, we have reached a point now where we can move for adjournment, if there's such a motion.
I'll move for adjournment.
Second?
Second.
Properly moved and seconded. Any need for discussion? All in favor, please signify by saying aye.
Aye.
All opposed? Thank you for your time, and be mindful that we gather again on the 16th, and on the 8th, we will be meeting online.